Hi, my name is Macy Stoneback and I'm a paralegal with AlphaTakes Counsel Law Firm. This video is for those forming an emerging technology company organized as a corporation. If you're like many company founders, you may be surprised at the number of documents involved for a very simple company. It may seem ridiculous for you as incorporator to elect yourself as a director and then approve the issuance of shares to yourself and appoint yourself as the company's president. I'd like to explain why completing all the incorporation formalities is important and then describe the incorporation process itself. I can think of at least 3 reasons why it's important to set a proper company foundation. First, to maintain the limited liability protection of a corporation, it's important to act like a corporation by observing corporate formalities. To do so, it's important to separate your shareholder hat from your director hat, your officer hat, and your personal hat. The second reason to incorporate properly is to save yourself a scramble before your first professional investor financing or the sale of the company. Investors and acquirers will expect that your organization is properly operating as a corporation. Getting your books and records in order from the start may save you from cleaning them up at the time of a transaction. The third reason to set up your company properly is to set founder expectations. It is important to define each founder's role and responsibilities and the rules with respect to each founder's shares. Now that you know some of the reasons for completing the incorporation formalities, I'd like to walk you through a typical incorporation process. The process can vary by company depending on the particular situation. First, an incorporator, which could be a person or an entity, files the document with the state to create the legal existence of the company. In Wisconsin, that document is called the Articles of Incorporation. In Delaware, it's a Certificate of Incorporation. Both are commonly referred to as a charter. The charter states, among other things, the maximum number and type of shares that may be issued and the person or entity in that state who will be the registered agent for legal service. After the charter is filed, the incorporator then usually designates the first members of the board of directors. The directors typically then ratify the incorporator's actions, adopt the bylaws, appoint the officers like president and secretary, approve the issuances of stock to the founders, and other actions. The bylaws governs how shareholders, directors, and officers interrelate and describes their respective powers and responsibilities. Stock issuance is a key part of the incorporation process. For an emerging technology company, the company and each founder often enter into a restricted stock agreement stating a schedule of dates on which the founder must remain with the company to retain his or her shares. If intellectual property, IP, is being contributed by a founder as consideration for the stock, the founder typically assigns the IP to the corporation. The founder receives either a physical stock certificate or, if allowed under state law, a paperless stock ownership statement referencing the shares. There are often confidentiality and invention assignment agreements between the founders and the company to cover how confidential information and newly developed IP are handled prospectively. If the company is bringing on employees or consultants right away, it's common to see the company also setting up a stock option plan and a shareholder agreement at the time of incorporation. Additionally, the company addresses various tax and state filing requirements such as obtaining a federal tax ID number needed to open a bank account, getting a state tax ID number if applicable, registering with the unemployment and workers' compensation offices, applying to transact business in other states. In addition, founders often file an 83B election for their restricted stock. As you can see, there are a lot of documents and steps involved with incorporation. It's important to set a proper company foundation for limited liability protection, to avoid delay at the time of financing or sale, and to set founder expectations. I hope this has helped you understand the reasons for incorporating properly and the incorporation process itself.